My name is Angela Fernandez. I'm a law professor at the Faculty of Law at the University of Toronto in Toronto, Canada, where I teach, amongst other subjects, legal history and animal law. The history of animal law can be helpfully carved up into at least three distinct moments. First, there are the 19th century animal welfare statutes that were first passed in England in the 1820s and followed shortly thereafter in jurisdictions like Canada and the United States. You might think of these as having established for certain non-human animals small r rights. For example, horses drawing carriages in the streets were often thirsty and not given water. So a statute was passed to require water troughs for the thirsty horses. The second moment comes much later. It's in the 1960s and 1970s. And here, the discussion is less about these small r rights, and it's more about capital R rights for non-human animals. The example, then, of the horses is less about providing drinking water for the horses and more about questioning whether they should be used at all to draw the carriages. You might think here of PETA, People for the Ethical Treatment of Animals. They were founded in 1980, educating the public about the horrific conditions on mink farms and encouraging people not to wear fur. The idea here was not better food and water for the mink, but really to question whether they should be bred and kept at all. The third moment is really the establishment of animal law as a field of study. And here, what do I mean by field? Things like courses in law schools on animal law, professors focusing their research in the area. One way to date it is to think about when the first journal on animal law came into being. And that was in 1995 at the Lewis and Clark Law School in Portland, Oregon. I came to animal law very much sideways as a legal historian first. I was working on a book about a famous property case called Pearson and Post. It's about a fox that was being hunted by a young man named Lodowick Post in 1802. He was hunting the fox with his dogs and thought he had sufficiently declared his intention to take this animal. However, another young man, Jesse Pearson, intervened and took the fox. He's later described as the saucy intruder. The two men, they could have taken to fisticuffs and gotten into a fight, but instead, Post decides he'll go to law. He goes to the local justice system, and there is a jury trial. The jury agrees with Post that there was something wrong with what Pearson did, being a saucy intruder, intervening and taking, but the wrong was not worth very much. They gave him only 75 cents, which even in 1802 was not very much money. And really, this case probably should have ended there. But it didn't, and the reason why it didn't was because Pearson had a cousin who was a fancy lawyer in New York City who appealed the case for him to the New York Supreme Court. At that court, the majority reversed the decision of the local lay justice and sided with Pearson rather than Post, using a rule that came to be known as the capture rule, which is the idea that the securest, best way of establishing occupation of the animal is to make sure that it can't escape. The competing rule, which was put forward in the dissent, is called the hot pursuit rule sometimes, and that is this idea that's quite popular with hunters, which is that once you've started chasing and you've made it clear that you have an intention to take the animal, well, then other people should really respect that. That dissent was written in a humorous style, so the judge who wrote it, he was the one who coined the phrase saucy intruder. And that dissent was very important to the case because even though it was ignored for about 150 years, eventually people came to include this case in law school casebooks. Pearson and Post assumed a prominent place, often as the first case that students would encounter in their property class, asking this question: what is possession? How do you establish possession in a wild animal? I was working on this case quite intensively as a matter of legal history, so looking at the social history, the lawyers, the literary history, trying to figure out whether that humorous dissent fit into a pattern of cases, even modern cases that tend to deal with non-human animals in a humorous way. And also this intellectual trajectory story about different generations coming to the case and very much projecting their own interests on it. That was my interest as a legal historian. One day, I went to lecture about the case in the property class of a colleague of mine, I got to the end of the lecture part of the class, and a student in the back, she put her hand up, and she said, "Professor Fernandez, weren't they both trying to kill the fox?" Her question very much stopped me in my tracks, because she was quite right, they were. This really led to then discussion about whether it was appropriate for the fox to be thought about as property at all. This was quite a brave thing, I thought, for her to do, given that she's sitting in a property classroom and the whole question is being presented and framed to you as a property question. But we want to know, well, why is the fox property? If the fox is property, then who's speaking for the fox's interests? This was a very important moment for me because her question really stuck with me and haunted me in a sense. And I started to feel quite bad about the fact that I was, in my legal historical role, profiting in a way, just like all the legal professionals had done for the last 215 years from the death of this poor animal. So at the point of publishing the book, when I was asked to give my input on what the cover should look like, I suggested that we use this painting, which is a picture of an eagle snatching the fox. And I thought that it represented this idea that over this long history, the fox has been appropriated and reappropriated for various purposes without having their interests being considered. Now, there are many understandings of foxes, many symbolic understandings of foxes. One of them is that, for instance, if you were to see one, you are meant to try to think about whether there's something in your life that is happening that you need to try to look at in a new way, that you're ready for a change or some kind of orientation, new understanding. For me, this fox moment that I was having with this project in this book was very much about then trying to transition into understanding more generally what the law was doing to protect non-human animals. And I was quite horrified to discover that the law was actually not protecting non-human animals. Either there was no law, or the law that did exist was of this paper tiger sort, which is to say that you read it and it sounds good. It sounds like it's going to be protective. It's got teeth, it bites, but in practice, it doesn't really work because there is a proviso exempting the behavior that you were hoping to prohibit in the first place. To take a particular example, you might think of fish, which is an animal that's important. Where I grew up in St. John's, Newfoundland, we really were not encouraged to think about fish as sentient beings. They were really just the economic resource. Fish, we now know, are sentient creatures. They can feel pleasure and pain, and so you would think, well, they need to be protected like other non-human animals under animal welfare statutes. If you look in Newfoundland, there's an animal welfare statute that would seem to apply to fish because it says all animals that have a vertebrae are protected. Fish have a vertebrae, so you think, well, they must be protected. Except for there is a proviso which says that unless otherwise regulated. And there are other regulations relating to fish. Particularly in Newfoundland, there's the Aquaculture Act, which applies to farmed fish. The primary farmed fish is salmon. And there are no welfare protections in this statute. Environmental law often works this way as well. So again, to continue using the example of fish, the Fisheries Act in Canada says you can't deposit any deleterious substance into an environment in which fish live. Again, that sounds great, except for it also says unless regulations permit otherwise. And the regulations do permit. What would those substances be? Well, antibiotics are an important one because fish, like all farmed animals, are kept in conditions that are very unnatural, very closed together, and so disease is a real problem, and antibiotics need to be used. Over time, the antibiotics become resistant, and so to the sea life, which is the problem, the parasite that's being treated. And so you have to, instead of just feeding the antibiotic to the fish in pellets, you actually have to douse them in it. And so that's going to create excess that ends up in the ocean. Similarly, in terms of substances that are being released regularly, waste. All CAFO operations are going to produce tons and tons of waste, feces. And in the case of farm fish, they're living in net pens in the water So the waste is falling to the bottom through the holes in the net pens to the floor. All the uneaten food is also falling down there. And they create dead zones in the ocean underneath the cages. This pollution, in turn, triggers toxic algae blooms, which contributes to a deoxygenated environment, which is putting those fish at serious risk. In 2019 in Newfoundland, there was an incident in which at least 2.6 million fish were slowly smothered to death in this kind of deoxygenated water. The report that was done from the Memorial University of Newfoundland called this a mass asphyxiation event, which means that what was happening was the fish were dying, they were pulling down the net, the walls were collapsing, so more and more of the fish were slowly dying over this very long period. But neither the report nor the media talked at all about the suffering that would have been created for these animals in this horrible manner of death for them. My Fox moment then has really been understanding how little the law is doing to protect non-human animals. I've been a law professor for over a decade, and I didn't know this. So how are other people who don't have access to all of this legal information supposed to be informed? So then the moment of change or transition for me was really about thinking, okay, I see this now, I know this, so what can I do in my role as a law professor to help spread awareness and improve this situation? The dominant thesis in animal law for the last 25 years has been that the primary problem for non-human animals is their property status. The solution to this problem is to move non-human animals from a category of property to the category of persons. Gary Francione wrote an influential book in 1995 called Animals, Property, and the Law. In it, he argued that property was the primary problem for non-human animals for a very specific reason, which is to say that whenever their interests were balanced against a human interest, however trivial or insignificant, they would be outweighed by the human interest. For example, a person going away on vacation finds out that the boarding of the dog is going to cost more than getting a new dog when they get home from the vacation, so they decide to have the dog put down. That would be an example of a trivial interest outweighing what you would think of as the more significant interest in the animal's right to life, but because they're property, it is outweighed. Also starting in the 1990s, Stephen Wise and his group, the Non-Human Rights Project, began to argue not for the ethical sense of personhood that Francione had been talking about, but for the legal personhood of non-human animals. Here it's very important to understand that legal personhood is not a natural category. It's fictional or artificial. It's this idea that an entity can be viewed as being like a vessel, holding some rights, but not other rights. A corporation, for example, can have the right to own property, to contract, to sue and be sued, even have the right to free speech, but not be able to vote and do other things. So in 2013, the group started litigating cases on behalf of imprisoned chimpanzees, arguing that the habeas corpus right, which is the right to be free from unlawful detainment, should be extended to the chimps. While very laudable, this strategy has been a bit confusing because, on the one hand, what the judges are hearing is that legal personhood is what is being sought, this vessel sense of personhood. However, at the same time, there is evidence being brought about the person-like understanding of these non-human animals, evidence about their cognitive capacities, for instance, and their social and emotional needs. And so the idea is that they are human enough to be given this particular right. And it's running up against an outrage factor that people have because they think that human being is not appropriate for non-human animals, however cognitively advanced they are. The problem is also the argument is not landing correctly in common law jurisdictions, in part because of the differences between common law and civil law jurisdictions. In civil law jurisdictions, legal personhood is understood in a more abstract and general way. So there's a tripartite distinction that goes back to Roman law, Gaius, of persons, things or property, and actions. And every civil law country has a code that is structured around those divisions or those distinctions. However, common law countries tend to think of legal persons just through these examples, like corporations or ships or municipalities or the state. Well, common law comes from England. It was exported from England to jurisdictions like the United States in the 17th century, before they were even the United States, also to Canada, to other settler colonial societies like New Zealand and Australia. Civil law countries, on the other hand, are countries like France, Germany, Spain, Austria, Switzerland, and it was imported in colonization efforts to Latin and South America. There are mixed common law civil law jurisdictions. So where I went to law school at McGill in Quebec, that's a mixed jurisdiction where they're taking elements of each. They have a civil code, but they also have a lot of common law features. Other mixed jurisdictions include Louisiana, which you're American, you might not have ever heard that. Scotland is also a mixed jurisdiction, common law, civil law. And then there are jurisdictions which mix religious or customary law with either common law or civil law. So in India, India mixes common law with religious and customary law. Japan and China mix civil law with religious or customary law. The point I want to make is that the personhood argument lands or sounds differently depending on which of these jurisdictions you're in. So if you're in a civil law jurisdiction, you might be more used to thinking of legal personhood, not just as these discrete examples that you are thinking might not be totally analogous or fitting with each other. In civil law, it's a doctrinal area. So you can pick up a book and it'll be called the Law of Persons. And every code starts out with the book on persons. The only jurisdiction where the habeas corpus argument for non-human animals has worked is, importantly, a civil law jurisdiction, Argentina. And there it was used in a case involving an orangutan named Sandra, who was declared a non-human animal and the subject of rights, including the ability to be moved to a sanctuary that was more appropriate for her. She languished for many years in a closed zoo in Buenos Aires, and in 2019, she made it to a sanctuary in Florida. So it worked in Sandra's case, in part because of the civil law jurisdiction of Argentina. However, a civil law jurisdiction is not going to mean it will always work. An example here would be Colombia, which is a civil law jurisdiction, and here there was a bear named Chucho, and his habeas corpus claim was denied in 2020. The legal system in which personhood for non-human animals actually makes the most sense is not common law or civil law, but actually indigenous legal systems. And in indigenous legal systems, there's no question that non-human animals are persons. They are teachers, they are kin or relatives, and they are not dissimilar from trees, lakes, rocks, anything that is spiritually important and that can teach lessons. And so this helps explain why we've had, for instance, a river in New Zealand that's important to the Maori people be recognized as a legal person. There's also a river in Quebec that was given legal personhood status that runs through Cree territory, but it's also because it's Quebec and it has this mixed tradition in which people are hearing the legal personhood argument a little better. There are examples in the US where rights of nature have been found, legal personhood of a certain kind. So some areas of Pennsylvania for water protection, also an area in Lake Erie was given a Bill of Rights by the city of Toledo after there was a toxic algae bloom caused by CAFOs that were surrounding that area of Ohio, and people couldn't drink the water anymore. One of the explanations then for why rights of nature can work, and can work even in a common law jurisdiction, is that people are confronted with the problem on their doorstep. So there's no way you can ignore this. You can't drink your water. And there will be a political action that will galvanize around that and try to find whatever legal strategy is available for redressing it. This is not as available for non-human animals because they are so invisible. They are behind closed walls, on private property. They can't pick up the phone and call the police. So we don't have the same kind of, we don't feel the same kind of urgency. Also, rights of nature are, unless you're in an indigenous frame of mind, they're not going to land or sound problematic from the point of view of being equated to human beings. You're not going to think of them probably as being analogous to human beings. So that outrage factor that's related to speciesism and human exceptionalism is not going to kick in as much. Now, in the US, the obstacles are this outrage factor that is kicking in. And I think that there are two very important lessons we need to be drawing at this stage of things. The first is to take into consideration the importance of jurisdiction and cultural background and context. That personhood, legal personhood specifically, sounds or lands differently depending on what jurisdiction you're in. Secondly, there's a lot at stake when we're looking at the distinction between property and persons. What is at stake specifically? Well, if the personhood argument for non-human animals is rejected, then we are left to fall back on the property argument. And property, that is the hopeless and abject space that the field has been spending 25 years eloquently and persuasively arguing cannot work for non-human animals. So we have a problem. It's a kind of trap, really. Even if certain non-human animals make it into legal personhood, so chimps and elephants make it, that's going to leave out the vast majority of all the other animals like fish. It also means that the animals that don't make it in have their animality emphasized. So the human enough animals are going to be like the humanized animals, and then there will be the animalized animals. And then that's going to reproduce all of these distinctions and problems. At this point in the field, it's important, I think, to back up and try to tell the story in a different way, where we don't fall into this trap of thinking it has to be property or persons in this mutually exclusive, binary, black and white way. Hence, we need to ask, what other possibilities are there? What are the alternatives to the person's property binary? We need to come at this from both the property side and the personhood side. First, property. Without a doubt, non-human animals are categorized as property under both the common law and civil law. This means that they are thought to be akin to inanimate forms of property, like pieces of furniture. Yet we know that a dog is not the same as a sofa. The law is increasingly recognizing this in a number of situations. First, take separation and divorce. The question often comes up, who gets the family pet? Increasingly, in a number of states, judges are being told to take into consideration the well-being of the animal or the interests of all concerned. This is very different than the way the dog would be treated if they were akin to other forms of property that the couple are sharing. Usually, one person would say, I'm taking the sofa, you take the dining room table, or the person who takes the sofa has to pay the other person half the market value of the sofa. But in the case of the family dog, we'll probably have a negligible or zero market value, and so we need to have a more nuanced approach, which is increasingly being recognized in a number of states. Secondly, wills and trusts. Many people worry about what will happen to their companion animal after they die. In the States now, it is legal to make a companion animal a beneficiary of your will or create a trust for them that can provide for them after you pass away. It is a very special form of property, then, that can be the recipient of this kind of generosity. Thirdly, emotional damages. Here, these are situations where your companion animal might be killed or injured, and you are bringing in action to try to get damages for that wrong. Again, a number of states are increasingly recognizing that the amount of money you get shouldn't be confined to the market value of the pet, which again will be negligible or zero, and that the damages should include emotional distress, loss of companionship, and perhaps even punitive damages depending on the circumstances in which this occurred. Fourthly, we have domestic abuse situations, and here it is possible to have protective orders which will include a person's companion animal, because we know commonly a target of the abuse will include and extend to the non-human animal. Relatedly, shelters are also increasingly allowing people to come with their companion animal, recognizing that they're not going to leave them behind, and also recognizing that they really are a different kind of property than the other forms of property that they may be forced to leave behind. The examples to recap are separation and divorce, wills and trusts, emotional damages, and domestic abuse situations. In all four of these examples, what we are seeing is the law recognizing that, yes, non-human animals are property, but they're a special form of property. They're property plus. They're more than mere property. They are quasi-property. Legal scholars have put forward a number of proposals to try to capture the nature of this special property status. These proposals include living property, sentient property, companion animal property, semi-property, inimitable property. There are problems with each of these. Living property is too literal. Sentient property builds into the term something that might be controversial, say for fish and sentience. Companion animal property is too narrow because it's not including animals that aren't pets. Semi-property, again, is too literal because it means exactly half, and we're not really talking about something that should be quantifiable in that sense. Inimitable property is problematic, first because it's difficult to say, and secondly, it doesn't have a meaning that necessarily everybody will know. So there are problems with all of the proposals. Quasi is best because it connotes what is actually being described. It is a kind of, it is a resembling, but not exactly the same. So a resembling of property, but not being exactly the same as property. Quasi is also a known legal concept. Black's Law Dictionary has 10 entries under quasi. They include things like quasi-contract, quasi-judicial, quasi-administrative. There are 23 examples in the entry describing known quasi-terms, like quasi-crimes. It's an excellent term, then, for the in-between space that lawyers are pretty comfortable and familiar with. Is it too vague because it is a kind of or a sort of? Well, lawyers and judges love vague. Gray space. Think of the lawyers in Pearson and Post. This is their stock and trade. Quasi then has the virtue of being neutral, being descriptive, marking a resemblance to property but supposing a difference from property. It is not controversial, and it's capable of being used widely as social notions and scientific understandings grow and change. Coming at things now from the personhood side, it is important not to forget the small r rights that non-human animals have had since the 19th century under animal welfare statutes. These statutes are grossly inadequate, but do implicitly recognize that non-human animals are already legal persons of some kind. Why? Because they have some rights, these small r rights, and only legal persons can have rights. The type of personhood is, however, this quasi or splintered kind of personhood. There is historical precedent for thinking about personhood in quasi or splintered terms, under both Roman law and common law. This is difficult territory, but the examples are important. In Roman law, slaves were discussed and appeared in the book on persons, not in the book on property. And slaves could own property with the permission of their master. They could be liable for their own crimes. So there was something there in terms of not being the same as inanimate property. Married women under the common law weren't property per se. However, they were at risk of being treated as if they were property because upon marriage, they lost their separate legal personhood status, their ability to sue and be sued, own property, enter into contracts. However, there were things that they could do, like be a guardian to minor children, issue a receipt. They could have separate property under a trust arrangement, and again, be liable for their own crimes. This is sometimes called onerous personhood because it's burdensome, and it mostly favors the husband or the master. Yet there is something there in terms of a recognition, like those small r animal welfare rights. They're not good, they're not great, but there is a bare bones legal personality there, and hence the ability to have rights that can then be augmented and made more meaningful. Abolitionists like Francione and Wise already recognize that the personhood that non-human animals have will be of this splintered quasi-kind. Francione, for instance, talks about the rights of non-human animals, and they wouldn't include driving a car, getting an education, or even voting. For Wise, he often says that the group is not looking for human rights for chimpanzees, but chimpanzee rights for chimpanzees. And so the examples show that this form of personhood is already this partial, quasi-splintered sort. The idea then is that it would be better to call it that and thereby avoid triggering this outrage reaction. Person is not good because it is so anthropocentric. People hear human being. It hits that outrage button in people who want to keep a sharp line between Homo sapiens and all the other animals. This is speciesism. This is human exceptionalism, no question. It is deeply ingrained. And that in and of itself makes it very difficult to overcome. However, we have to add on top of that currently dominant eating practices, which even for people who have stopped eating animals or using animal products, you have to take in and digest this idea that for the previous, in my case, 40 years, I've been engaging in a system that is sadistic. And on top of that then, if non-human animals are persons, it's really a form of cannibalism then that I have been doing for those 40 years. This is a lot to ask people to accept and triggers very much this kind of shutdown, no way reaction. Quasi-hood then, quasi-property, quasi-person, is a way to provide a working term that won't trigger the reaction. It does retain person, because you need person in there in order to get rights, because you need rights. But calling them quasi is a way to make it palatable or acceptable. And then working over time, as social understandings change, we can dampen down the property aspects and augment the personhood aspects. This is certainly going to change as the current dominant eating practices, factory farming, is not sustainable. Until we get there, though, to this tipping point, it's very important for the legal notion to be open and flexible in this way that doesn't cause people to shut it out. Legal categories here lead. They help structure thinking in a good direction, but they also can follow where things are going, socially speaking, as consensus develops around some of these important issues. The quasi-idea, then, is really a Fox moment for the field of animal law. It's a request, in a sense, to stop talking about property or personhood status in binary or black and white terms, and perhaps even to stop talking about property and personhood, period. To give an example that comes from Canada, we had a bill that was passed recently to ban the future captivity of whales and dolphins. And it was put forward by an Indigenous senator who didn't frame it in terms of personhood or property. It was just a ban on cetaceans in captivity. This senator was prompted to do this because his granddaughter had seen Blackfish, the documentary film about SeaWorld, and asked him what was he doing to help the situation. That bill was put forward and passed without getting into the question of whether or not the cetaceans were property or whether they were persons. And that might be the best way to try to accomplish things and get things done. However, lawyers will often push. That's what they've been trained to do. And if there is pushback, then give them something quasi, give them something gray that they will love to play with, like the lawyers in Pearson and Post. these gray zones of quasi, not the black and white property person's binary and the trap that that binary creates.